Have you ever co-signed a loan or maybe made a financial promise for a friend or family member? It seems pretty straightforward, right? An act of trust. But what happens when it all goes sideways? Well, we're going to break down a legal case that shows the staggering price of a promise, and honestly, it might make you think twice before you sign on that dotted line. So this is the big question, right at the heart of our story today. You put your name down, you personally guarantee a loan to help a business get going. But then, the business fails. The company itself might be gone, but what about your promise? Where does your personal responsibility actually end? And to get to the bottom of this, we are diving deep into a real-world case, State Bank of India versus V. Muthuchandrasekhar. The court's decision here is a perfect and kind of scary example of just how serious a personal guarantee can be. Okay, so first things first, let's really nail down the foundation of this whole situation, the role of a guarantor. When you sign that piece of paper, what are you actually promising to do? In this particular story, you've got three main players. On one side, you have the creditor, the State Bank of India. They're the ones who loaned the money. Then there's the corporate debtor. That's the company that got the loan. And finally, the individual who's caught right in the middle, Mr. V. Muthuchandrasekhar, the personal guarantor. You know, being a personal guarantor isn't like being a character reference on a resume. Not at all. It is a legally binding promise. It means that if the main borrower can't pay, you are on the hook to repay the entire debt. That is a massive, massive financial commitment. All right, let's move on to the next chapter here and see how a simple loan default starts to snowball into a full-blown insolvency case. You can literally see the dominoes falling here. It all starts when the company defaults on its loan. The bank then has to flag that loan as a non-performing asset, or an NPA. Pretty soon after, the company itself goes into liquidation. But for the bank, the story isn't over, not by a long shot. They now turn their full attention to the guarantor, and they use a very powerful tool to do it, Section 95 of the Insolvency and Bankruptcy Code. Now, the key thing to understand about Section 95 is that this isn't just some strongly worded debt collection notice. Its entire purpose is to officially kick off something called the insolvency resolution process, a formal legal procedure that's aimed directly at the individual guarantor's personal finances. And this process, it follows some very clear steps. First, an independent person called a resolution professional gets appointed to look into the whole case and file a report. Then, a public notice goes out inviting any and all creditors to file their claims. But it's this final step that's the most critical of all. The guarantor is required to submit a formal plan for how they're going to repay the debt. But as we're about to see, that crucial step, well, it just didn't happen. And that takes us directly from what could have been a resolution to the much, much more severe path to bankruptcy. So this right here is the turning point of the entire case. What was the one single action, or in this situation, the one single inaction, that completely changed everything and sealed the guarantor's fate? And here it is, the fatal mistake. The personal guarantor never submitted a repayment plan. To the court, this wasn't just a missed deadline. Oh no, they treated it as an outright rejection of the entire process, as if he had actively and deliberately refused to cooperate. And that interpretation? Well, it changed the whole game. It gave the bank the legal green light they needed to escalate, allowing them to file for personal bankruptcy proceedings under a whole different part of the code, Section 121. So, to manage this final and very serious stage, the court brought in a new key figure, Mr. Ajay Gupta. He was appointed as the bankruptcy trustee, and he was now responsible for overseeing the entire process from here on out. So, the bankruptcy order is passed. But what does that actually mean for the person? What are the real-world, immediate consequences of being declared bankrupt? Well, the outcome was definitive. The tribunal's gavel fell, and Mr. V. Muthuchandrasekhar was officially and publicly declared bankrupt. And the effects? They are instant and they are far-reaching. His entire estate, we're talking all of his personal assets, are immediately taken over by the bankruptcy trustee. He's then required to submit a full statement of all his finances in just 7 days. Public notices are published, and a legal shield goes up, meaning no new lawsuits can be filed against him without the court's permission. And believe it or not, it doesn't stop there. The bankruptcy order comes with some serious, long-term legal disqualifications. These can actually prevent someone from holding certain public offices or being a director in a company. And these restrictions stay in place until a formal discharge is granted, which is a whole separate and often very lengthy legal process. So if there is one single thing to take away from this entire case, it's this. A personal guarantee is not a backup plan. It is a direct, standalone promise. The court made it crystal clear that the guarantor is fully accountable even if the original company that took the loan is long gone. The two debts are seen as completely separate. This case really leaves us with a critical question. In a world where the line between our personal finances and corporate finances is getting blurrier all the time, especially for entrepreneurs, how does the law strike the right balance? How can it protect lenders who need security without completely wiping out individuals who risk everything on a simple promise?